Next case to come before the court is Faith Fatokun v. Peter Fatokun. Each party will have up to 15 minutes to present their arguments. Appellant may reserve up to 5 minutes for rebuttal. And if you do plan to reserve time, please let me know, as I'll be keeping track of the time. The arguments are being recorded, so please remain behind the podium, keep your voices up, introduce yourselves. You should not use the names of children or minors or victims during your argument. You can refer to those folks by initials or generic terms like child or children. We have read your briefs and we're ready to proceed when you are. And I would just ask appellant, would you like to reserve time for rebuttal?
Yes, please, Your Honor. I'd like to reserve 5 minutes if I may.
Okay, very well. Then you may proceed when you are ready.
Good morning, Your Honors, and may it please the court. My name is Karen Coble, and I represent Ms. Faith Fatokun. It's an honor to be here today for the first time before this court. As this court is probably aware, having read the briefs, I was not on brief. I was brought on late in this matter, and so if occasionally I am on my back foot, I apologize in advance. I'd like to use the majority of my time to talk about the custody issue, because that's the primary issue in this case, and it's Ms. Fatokun's primary concern. I don't know that I have ever seen language in a judgment entry that is this vociferous, accusing Ms. Fatokun of obstructing Mr. Fatokun's ability to be a father, presenting no credible testimony that father's been abusive or mistreated in any way, not finding her credible and not finding any of her allegations credible.
Right, I wanted to get to that. I'm glad you're at that already.
That's where I'd like to begin.
So there was a
yes.
criminal charge, right?
There was.
Or is it early in the case?
It's when the case first began, when the parties first separated. There was a domestic violence incident.
And an officer had a probable cause affidavit he took to the courthouse. Is that in the record?
That is in the record, Your Honor. I submitted, the trial court would refuse to allow any police reports into evidence.
Was the protection order in the record?
Not that I believe, Your Honor, it was not. Unfortunately, because Ms. Fatokun told police that evening, I actually submitted the police report. There's currently a pending motion for a stay before this court.
But there is something in the record that a judge issued a protection order, and that he would, and it didn't involve the kids and?
Everyone agrees, Your Honor, and that's not disputed, and it covered both Ms. Fatokun and the children. In it, and in that police report that was submitted on objections and in reply to Ms. Fatokun's motion for a stay, Mr. Fatokun said, "I will cut you up into tiny pieces and bury you in the fields." And the trial court, after several years of this, may have found this to be hyperbolic. And I will concede that we have seen, and I'm sure this court has seen, many family law cases where false allegations are made in order to get a leg up or in order to manipulate a court. But I've worked with domestic violence victims, helping them get civil protection orders. And death threats are more than sufficient for the civil protection order that was in place here today. Ms. Fatokun did not dismiss the domestic violence charge. There are varying explanations in the transcript for why that protection order and that domestic violence charge was dismissed. Some say that it was mischarged. Some say that the prosecutor wanted to dismiss it and leave it to family court to decide because he didn't want to be inserted into a family law dispute. At one point it was suggested that Ms. Fatokun come into the courtroom, and this was testified to, it's in the transcript, to object to the dismissal of her domestic violence case. She refused to come up into the courtroom. She was too afraid.
Was anyone asking for Dad to have sole custody of the children?
Dad was at first asking for shared parenting. The guardian ad litem said repeatedly, these parties have no ability to communicate whatsoever.
So Dad submitted a shared parenting plan?
Correct.
And that was the position, that was his position at the time of trial, that he wanted shared parenting?
I believe that remained his position throughout after he submitted the shared parenting agreement. Interestingly, though, Your Honor, the guardian ad litem recommended that mother despite all of her allegations that were found not to be credible, that mother have parenting and be the sole custodial and residential parent in Texas, where she moved to. I think part of what happened in this case was the trial court was upset by this civil protection order being in place for a year because it didn't allow Mr. Fatokun to see his children except for with supervised visitation. The trial court was also upset that Ms. Fatokun moved to Texas against court orders that she remain in Ohio. There are several explanations for this, however. The marital home was sold. It's undisputed that Ms. Fatokun and the children at that point were homeless and they were living in a hotel. She took the children to Texas for two reasons. One, she has family and a support system there. Second, she was able to find a job there and in fact is working there in Texas.
So this is what I'm confused about. The beginning of the entry says that the parties have lived in Lorain County for the last 90 days and 6 months in the Lorain County. No, it was 90, I don't have it right in front of me, but, and then we were saying that she was actually living in Texas?
At the time of filing, Your Honor, it's undisputed that she met the jurisdictional requirements.
Okay, so you're saying sometime before the case, the trial, she had undisputedly moved to Texas.
This trial took place and trifurcated. It was split into 3 different hearings over the course of about 8 months. And so during the middle of this, while she was homeless after the marital home had been sold, she did move to Texas, yes. She took the children to Texas first for spring break. She was able to find work there. Family said that she would be supported there. So that was her option. She had very limited options at that point. And despite that...
Was that in violation of a court order?
Yes, Your Honor, it was. Because she had very limited options at that point. Again, she was living out of a hotel here in where her home was. She didn't have any work, and that's for several reasons. One of the reasons is that Mr. Fatokun was, according to multiple accounts, not just Mr. Fatokun, he was incredibly controlling of her, would not let her leave the home without permission, considered and testified that he was the head of household, and so he had to be in control of things as the head of the household. Mrs. Fatokun started telling people about the abuse that was going on far before the divorce was filed, and her stories have been consistent throughout. And she has good cause to be concerned, as this court will see in the motion for a stay that's currently pending before this court. Father now has custody of the oldest son, who is a teenager, and he slammed his head into the floor, causing a visible bruise and a goose egg on his forehead. That picture has been submitted to the court. These are, and not to go off the record, but fairly.
Make sure you don't go off.
I won't go off the record then, Your Honor, but fairly soon more motions will be filed about this abuse. She's been reporting abuse since 2014. She offered police reports since 2014. She offered testimony that in the Nigerian culture, where both parties are from, the man is the head of the household, and it's a very patriarchal situation. Again, he testified. He considers himself the head of the household, not a co-head. 3 witnesses testified that Ms. Fatokun testified to abuse. The oldest son told the guardian ad litem that his father stripped him naked and beat him with a stick. The oldest child told the guardian ad litem that the father pulled him up by his ears so hard that his ears were bleeding. Mr. Fatokun admitted on the stand that he bought property in Nigeria, his homeland. And when Mr. Fatokun left the home after the domestic violence incident and his arrest, he took the children's passports with him. Thanks to that protection order, the passports are now in the possession of Ms. Fatokun's trial counsel so that neither party can take the children out of the country. But this was a repeated threat on the part of Mr. Fatokun. He wouldn't let Mrs. Fatokun work full-time. He denied her access to business accounts. The The guardian ad litem knew about the abuse and still recommended that Ms. Fatokun have full custody in Texas. Now, I can certainly understand the trial court being upset at Ms. Fatokun disobeying court orders. And the trial court in its decision also noted that Ms. Fatokun on the stand admitted that she would not be facilitating any visitation time with father unless there was a court order because of the safety of the children. The guardian ad litem, because of the oldest son's allegations about abuse, also said in her recommendations that there be no corporal punishment whatsoever. Ultimately, the guardian ad litem recommended that the majority of the time with mother was in the children's best
You are
interest.
moving into your rebuttal time.
Thank you, Your Honor. I'd like to reserve my 5 minutes for rebuttal if I may.
Very well.
Good afternoon, Your Honors. Susan Lax on behalf of appellee Peter Fatokun. As this court's aware, I'm also a registered nurse, and I've done an extensive amount of work in rape and domestic violence in addition to my 37 years of practicing domestic relations law. I would have to dispute the analysis by my esteemed colleague. Judge Glass was probably one of the most patient, reserved people I've ever seen in her patience with both of these parties. I was actually quite surprised at just the incredible level of patience that she had. There was continual violations of court orders by Ms. Fatokun, complete disregard for the court, complete disrespect for the court. We've all seen cases where people use abuse as allegations to get advantage in custody. I believe this to be the case. The criminal case pended for a year. The children were put on the CPO. Despite great efforts, it was very difficult to get the municipal court to coordinate anything. It took us a year to finally get it to where we got the domestic court coordinated, and we were able to work something out that the children's matters be heard in the domestic court. So just about a year later, Peter Fatokun was allowed to have visitation. The order was put in March of 22. Ms. Fatokun obstructed those visits, and nothing happened until May of 22. There was a continual obstruction, and this is detailed in the detailed findings that Judge Glass made. As this court knows, this is an abuse of discretion, and great weight is given to what the trial court's analysis, since they have to sit there as a trier of fact. I sat there, I heard, Judge Glass heard, point after point after point of 11 contempts of missed, failed visits when they were supervised, failed when they were unsupervised, when the guardian recommended that there was counseling for Peter and their older child, the young man.
Please don't use their name.
Oh, excuse me, IF, I apologize.
We'll take
I,
it.
thank you. IF, that was not facilitated. There was excuse after excuse after excuse. Ms. Fatokun never gave her address as to where she was going when the house was sold. So these allegations that she was homeless, I have sitting in my account when they sold their house, $171,000 of money. We were allowed at one point, Judge Glass authorized, when we agreed, $15,000 apiece for attorney fees. So right now there's $141,000 sitting. At every time Mr. Fatokun offered, I offered, Mr. Berta suggested, let's give the parties $10,000, $15,000 out of this money if they need it for moving expenses. Right away could cut a check. Ms. Fatokun did not agree. Peter was also paying Ms. Fatokun, that's Mr. Fatokun, $1,400 a month, in addition to the findings by the court that she has a degree in HR, earning at least between $22 and $30 an hour, so the court averaged her at $25. This is a very well-educated, articulate lady. She is smart, she has worked, and the allegations that Peter is controlling, I understand the Nigerian culture. I have many Nigerian clients. Peter was proud of his wife. Peter did not want the divorce. Peter still loves his wife to this day. Peter had nothing but nice things to say about Mrs. Fatokun.
I have a
So the
question. We do have an older child here, right?
That's it, that's IF.
And that, was there an in-camera,
Yes,
and what's on the record about that?
not much.
So wouldn't that be an important factor here of where the older child wants to have where custody should go?
It was not made a part of the record, that I saw in the findings. I would imagine it would, but what I would also say is the child at the time, let's see, we're going back to trial in 23, he's now, so he would be 10 years old. But I will say also this, is that the court found is that the child was coached by mother, that even at the counseling sessions, the guardian recommended the mother went and coached and talked to the child, and every verbiage that came out of his mouth was adult comments. So I would suspect that anything that the court got would be the child talking through through his mother's eyes and mouth. With all due respect.
There's a statistic that 93% of mothers who make abuse allegations against fathers end up losing custody of their kids, and the theory on that is that the judge is punishing the mother for making the allegation if she can't substantiate it, instead of looking at the best interest of the children. Do you think the judge did that here?
No.
We're missing some things.
No, I don't think so at all. And if you look at 3109.04 at 1FA through I, it's very clearly that she discussed those factors, applied the facts as presented. She had competent counsel. Attorney Bird was a former judge. She had very good counsel in her trial court. All the facts were presented under all the criteria. The guardian testified. I mean, this was a fully developed case.
So you think that the factors about not facilitating visitation and the violation of the court order by trying to move to a different state support the custody of the father?
Absolutely. And not only that, even if you still have to look and see, can this child live with his parents? So I did that too, because I'm a parent, I'm a grandparent, you have to just because she's done wrong, you have to look at what's best for the child, not the parents, the children for what matter. But even looking at that, there's no evidence that Peter was abusive. In fact, the evidence is to the contrary. He's a loving parent. He loved his wife, went in contrary to, he didn't want to let her get a job. He helped her find jobs. He paid for her college. He helped her find things so she could be all that she could be, and not living in Nigeria. We all know that when people come from overseas, whether it's Jordan or whether it's Nigeria, a lot of international cases I do, women are oppressed. They come here and they get a new lease on life. Peter's whole attitude was he was proud of her and wanted her to be everything she could be. He thought she was smart. And so it's completely to the contrary. And if the court reads the testimony, that's what his testimony was, okay? Not to the contrary. There's no reporting to CSB or to the guardian of any of these allegations.
But there was a report to the police early on.
Early on in May of 21, when they were arguing, there was a report.
I have another question. Did your client ever ask for sole custody? Was that what he argued?
He did it in his complaint as an alternative pleading in the counterclaim, and also we put in, the court asked them both to put in a motion, a parenting plan, which we did at the request of the court, so we did. And Peter's was a shared parenting plan. Mother's plan was dad could have extended visitation in the summer, but not even could he have them himself. They had to be some third party designated by mother that he could go during the day and visit them. That's what she was willing to do. But even this time, there was no address. Nobody knew where she was living after the house was sold. We had clearly no idea. Mr. Berta wasn't able to tell us. I don't know whether he knew or not himself where she went and when she went to Texas. It was convenient that she would go to Texas during spring break when Peter could have had a chance to spend time with the children during the break in an unsupervised setting, but that was not made available. I will also tell this court that no matter how many times we had pending motions for contempt, they just went away because we just had the trial. None of that seems to faze mother. I mean, I hate to say it, but to me, it's appalling, to see that it's just a complete willful, flagrant disregard of anything the judge said. But as I said, if you read the transcript, I was there. She was just incredibly respectful and patient with all of these parties. Remarkably so. Remarkably so. And as to stripping this child naked, I will say this, that both parties had testified that they had spanked their children in the past. And, we discussed with both of them, Attorney Burden and I, that in this day and age, you don't need to do that. We just don't do that anymore. And they don't do that, anymore. But I have never heard of anything about him abusing these children, et cetera, and so forth, except what was claimed by mother. And if you read the guardian's report and the judge's findings, just the verbiage of this child was just so unbelievable to the guardian as to what was spewing out of his mouth. And that the only time mother didn't go to the counseling session was the last counseling session when the child, IF, said, "I'm not coming here anymore," counseling. The guardian substantiated no abuse. The guardian had no problems with the fitness of Mr. Fatokun as a parent. And I would state also, after leaving, as this court may or may not be aware, mother was ordered to return the children to father. She never did. We had to go get them and expend extensive sums of money with the writ of habeas corpus, with airfare to Texas, with hotels to Texas, with counsel in Lubbock,
If
Texas.
it's not in the record, we shouldn't discuss it.
No, I understand, but my point is just going prospectively forward, nothing has changed. So if just the court's looking to see if anything's going to change, I would respectfully submit, I don't think so. I don't think there's going to be any respect for what this court orders. I think Ms. Fatokun knows better than everybody else and is going to continue to disregard whatever this court does. There'll be no chance whatsoever for Peter to be a parent. On the contrary, Peter would do everything to facilitate a relationship, which he testified and is in the record, with Faith. And I will report the kids are doing well. They've been checked on by the guardian, going to school. I would just ask the court to affirm the trial court's decision. I think it was very carefully written with enough detail, applying all the factors under 3109.04 F1A through I, to give this court substantial reason to affirm the decision. Thank you.
Thank you. Thank you, counsel. Counsel, you'll have 4 minutes, 47 seconds.
Thank you, Your Honor. The guardian ad litem looked at the best interests of the children, and the guardian ad litem was also there, also saw supposedly Ms. Fatukin's obstreperous behavior, yet still recommended that she have the children in Texas and that father be given long-distance visitation. The guardian ad litem's recommendation should weigh heavily in this court's minds when it comes to believing her allegations of abuse. And of course, we don't know what happened in the in-camera hearing. Perhaps the judge found the oldest son also to be very articulate, but perhaps he inherited some of that intelligence from his parents to be that articulate. And he was in therapy. It doesn't take a child long to learn words like emotional abuse, verbal abuse. These are the type of words that gave the parties cause, that gave the judges cause. And I would, again, submit to you that this oldest son was a teenager. Teenagers are no strangers to words like emotional abuse. According to Mr. Fatukin's witnesses, these are all people who they went to church with. They're both very religious people. They saw Mr. Fatokun being a great father in public. Mrs. Fatokun admitted that Mr. Fatokun would occasionally help the oldest son with homework. And yes, Mr. Fatokun supported Faith and said nice things about her at the hearing on the stand. None of this is incompatible with a long, years-long pattern of abuse, and a pattern of physical abuse, a pattern of controlling the household assets, a pattern of controlling where she worked, when she worked, and why she worked. The guardian ad litem, despite all of this characterization of Ms. Fatokun as a bad person, the guardian ad litem still found, after talking with the children and after talking with Mr. Fatokun, that Ms. Fatokun never badmouths the father to the children. Never. And that's from the guardian ad litem. I would ask this court to take a close look at the transcripts in this matter. To me, the transcripts in this matter not having been at the trial court didn't show much patience when Ms. Fatokun was on the stand. There was a lot of crosstalk. There was a lot of difficulty understanding her because of her accent. English is her second language. There was a lot of difficulty by Mrs. Fatokun understanding what Attorney Lax was saying, because often the judge had to remind counsel that compound questions were too confusing, especially to someone whose second language is English. Your Honor, a counsel characterizes Ms. Fatokun's actions as excuses. I would submit that homelessness is not an excuse. And as for, yes, the house was sold. Yes, there were proceeds from the house. And as counsel pointed out, those proceeds are still sitting in her account. They haven't been distributed to Ms. Fatokun. She's been making do this whole time, by hook or by crook, with the small amount of spousal support allotted to her and with her own earnings from income. That's how she's been making it.
Is it disputed that she didn't follow a court order for supervised visitation?
She did not at first. That's correct, Your Honor. She did not.
Was there
And
ever
she
supervised
was
visitation then?
I'm sorry?
Was there ever facilitated supervised visitation at any point?
Yes, there was. Yes, and she did miss some visits. It's difficult to persuade an older son to go when he is manifestly afraid of his father, and that is ongoing. And while counsel said that she checked with the guardian ad litem and the children are doing fine, I got quite a different read from what the guardian ad litem knows what's currently happening with these children. And it is not in the children's best interest to remain with father. If there are no other questions, I see that I'm out of time.
Thank you, counsel.
Thank you, Your Honor.
Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The court reports will mail a copy of that decision to you on the day that it is released, and they will also be posted on the Ohio Supreme Court website.